Letter number 8. Marriage in Israel. From time to time, I teach a course on kinship. The last segment deals with contemporary marriage, where I am able to draw, I hope to my students' benefit, upon my legal background. One of the most notable pieces of marital litigation in recent history, both because it involved a Hollywood screen star and broke new legal ground, is the California case of Marvin versus Marvin, decided in 1976. Briefly, Lee Marvin, the screen star, and what would today be called his life partner, Michelle, lived together for 6 years. Something less than life, but a considerable period nonetheless. Though they did not solemnize their relationship with formal vows, they lived in most other respects as married people. And when the partnership broke up, Michelle sought rights normally reserved for a spouse. California does not recognize so-called common law marriage. In response to Michelle Marvin's claims, the California Supreme Court declared that, under the circumstances, she should be allowed to prove that she and Lee had an implied, that is, unwritten contract to share their income during the period they were living together. In other words, the court said the parties could, from their actions, be determined to have agreed to treat the property acquired from their earnings the same as community property. As such, it would be divided evenly between them, the same as if it were property to be shared between two spouses. And thus the tabloid's palimony wormed into our vocabulary. All of this was brought to mind late last year while reading a decision by the Israeli Supreme Court. The holding presents a not uncommon situation, one shedding light on the woolly entanglement of synagogue and state in Israel, as well as contemporary issues of marriage in the U.S. According to the newspaper Haaretz, S and Y, two middle-aged, native-born Jewish Israelis met 8 years ago and agreed to marry. They chose, however, to eschew the rabbinical route. Consulting with a lawyer, they elected the Paraguay option, marriage by forms and mail. As a consequence of its history of coalition governments and concessions on the subject to various religious political parties, Israel's law governing marriage rests in the hands of religious authorities. Inside Israel, civil marriages are not an option. S and Y lived together in their Tel Aviv apartment for 1.5 years and then split up. When the matter of a divorce came before a rabbinical court upon petition of S, that is the wife, the lower court ruled the marriage was invalid and denied her request for support. The case then moved to Tel Aviv District Court. There the court likewise rejected S's argument that the marriage had legal status, despite judicial recognition of civil marriages physically performed in Cyprus, which some Israelis use to get around their homeland's marriage law. Support payments for Jews marrying according to the laws of Moses and Israel are dictated by Jewish law. But until the case of S and Y, the law had been vague regarding non-rabbinical marriages. Rules governing claims, when such marriages break down, have never been clearly formulated. This is where Marvin versus Marvin enters the picture. The Israeli Supreme Court invoked the principle of good faith, applicable in the law of contracts. The decision also allowed the court to avoid deciding whether civil marriages performed abroad, or Paraguay weddings by mail, ought to be fully recognized as marriages in Israel. Rather than compelling support based on the ex-partner's status as married people, the Supreme Court justified payments on the grounds that the couple entered into a contractual agreement, even without signing any financial documents supplementing their marriage contract. Quote, "In a case where one party needs the support of another, the party is entitled to receive it," declared the court. The two parts of a couple are not pedestrians who were joined together by a road accident. The two persons agreed to live their lives together. Considerations of fairness and justice lead to the conclusion that obligations of alimony payment apply." End of quote. Fairness and justice is not exactly the language of contract law rulings. Reasonable expectations of the party would be better. But the incongruity of circumstances forced the court's hand. One immediate upshot of the unprecedented holding is that the contractual right can apply equally. An ex-wife could be compelled to make support payments to her former spouse. According to rabbinical courts, a wife under some conditions may be obliged to make support payments to her children, but never to a former husband. On an entirely different scale from the stakes for S and Y, there are the political fortunes of Shinui, the explicitly secular party led by former television personality Tommy Lapid. To the surprise of many, Shinui's performance in last year's election proved sufficient to command a prominent position in Sharon's coalition government, receiving cabinet posts of Interior and Justice. Much of Shinui's constituency come from the 300,000 Russian-speaking non-Jews who by law must either convert or take a cloudy civil alternative when deciding to marry. Naturally, they are pushing for fundamental change. Thus, shortly after the new government came into being, the Knesset, as promised by Shinui, launched the Committee for the Formation of a Proposal for Registration of Spousal Status. The awkwardness of the title suggests the level of enthusiasm. 9 months after its formation, the committee had held a single closed meeting. In addition to Israel's significant population of non-Jews, a growing number of couples eligible for rabbinate marriages choose instead to marry abroad. Israel's Central Bureau of Statistics reports that 5,600 Israelis made this choice in the year 2000. More than half opted for civil rights in Cyprus, representing a tenfold increase over the previous decade. For some, Cyprus is a luxury they cannot afford. "Where can we get the $1,500? asked a housekeeper named Regina, who was ruled ineligible for marriage by rabbinate researchers. Besides which, with the current state of unemployment, we cannot miss even a single day of work. We are the first ones who risk being fired." Some expect that eventually a solution will be found permitting couples to marry inside Israel where both are non-Jews. No one seems to hold much hope for so-called intermarriages, that is, between a Jew and a non-Jew. The National Religious Party, another coalition member, views such unions as a trapdoor to assimilation, a wholly unpalatable outcome. On the other hand, somewhat facetiously, Shinui has suggested that without new rules, the cost of the trip to Cyprus should be underwritten from the Interior Department's budget.